Welcome back, friends. So, in the last class, we've learned about the evolution of or the reason why trade union has formed and why it has formed, and we've seen what industrial revolution is, what trade union is, the evolution of trade union in India, the responsible persons who've brought in the trade union movement in India, etc. So, in this class, we are going to talk in detail about the Trade Unions Act of 1926, as well as the object of trade union and scope of trade union and some of the definitions. So, let's get started. So, I've already said that a trade union is a voluntary organization. So, it is a group of people that has voluntarily organized themselves as trade union, and it is for the interest of the worker, for the better working conditions, for securing proper wages, irrespective of sex, and how they are achieving, or what is the main way of achieving these things is by means of collective bargaining. So it is through collective bargaining that they strive to secure fair wages irrespective of sex, and also for the protection of interest of worker and for better working conditions. And next we are going forward. So next we're going to look upon the object for which the Trade Union Act, the Trade Unions Act of 1926 was formulated. So the primary object is for the registration of trade union. So what exactly is the use of registering a trade union? It's because, the main positive aspect of registering a trade union is that they get some immunities with regard to the civil or criminal liability. We've seen the Buckingham Mill case, that the Madras High Court has prosecuted the workers for the main people for instigating the workers to go for strike, right? So when the trade union is registered, they get immunities against such prosecution if it is for lawful purpose. And the other thing is, this act is only applicable for a registered trade union. There isn't any strict regulation that every trade union has to be registered. It is the discretion to register or not to register. But if a trade union is registered under the Trade Unions Act of 1926, and they'll get some immunities with regard to the same, and the unregistered trade union will not be illegal. Okay, so the act does not mandate that all the trade union has to be registered. The act also requires for the proper maintenance of the books of accounts of the trade union. So these are some of the objects of trade union, and let's move on. So next we're going to look into the scope of Trade Unions Act, that is the registration of trade union. So for the registration of trade union, there should be a registrar. So the act gives specifications with regard to who a registrar is, or how is he appointed, and by whom he is appointed, or the authority that appoints the registrar. So an appropriate government is responsible for the appointment of the registrar, and as per the act, each trade union has to make their own rules for the objects for which they have been formed. And as we have seen earlier, the act provides immunity for the trade union with regard to civil and criminal liability. And the other scope is that amalgamation of trade union, that is, different trade unions can be conjoined, amalgamated into one trade union irrespective of their individual existence. Okay, and the next one is, it also gives specifications with regard to the dissolution of trade union, and to secure fair wages, and to improve working and better living conditions, and to provide educational, cultural, and recreational facilities to provide individual as well as for the collective welfare. So from this we can understand that the Trade Union Act focuses on the overall development of the workers. So the, as we have already seen, employers can also make their own trade union, but the number should be very small. So the definition of trade union has been defined under section 2 clause H of the Trade Unions Act of 1926. So the definition says that it is a combination, or it is any combination that is either permanent or temporary, and its main purpose is for regulating the relationship between workman and workman, employer and workman, or employer and employer. So it is for such a reason that a trade union is being formed for regulating their relation. Okay, so one of the famous case that has been seen as Tamil Nadu NGO Union versus Registrar of Trade Union. So the facts of the case is as follows. The association represented by 10 members of the trade union gave an application to the registrar for registering it as a trade union, but the registrar has rejected their application. And why exactly is the reason for such a rejection is that the said trade union contained, the 10 member trade union contained members of sub-magistrates of the judiciary, tahsildars, officers in charge of treasuries and sub-treasuries, officers of civil court establishment and the home department of the government, and hence the court held that their union cannot be regarded or recognized as a trade union because these persons are civil servants, right? So their task, they are engaged in the task of the sovereign and legal aspect of the government, which are its inalienable functions, and hence the such association of members cannot be regarded as a trade union. And the next definition is with regard to executives. So executives is defined under the section 2 clause A. So they are the body of the trade union, and they are entrusted with the rights of the trade union, and unlike any other organization, there is a hierarchy of members. So it consists of a president, vice president, secretary, treasurer, or such bearers. So office bearers. So they are called as bearers of trade union, and there is no restriction with regard to the rights of the bearers. And the next definition is section 2 clause B, that is office bearers. The members of the executive body of the trade union is called as the office bearer. So far we have seen the definition of trade union that has been defined under section 2 clause H, executives that is defined under the section 2 clause A, and office bearers that is defined under the section 2 clause B. So the next important section is section 2 clause F, that is the definition of registrar. So who is a registrar? So as I've already mentioned, the purpose of the Trade Unions Act of 1926 is for the voluntary registration of the trade union, right? So who is responsible for the registration of a trade union is a registrar. So registrar is defined under the section 2 clause F. So registrar of a trade union is appointed by an appropriate government, and as per the section 6 of the act. It also includes additional or deputy registrar of the trade union. Further details with regard to registrar, appointment of registrar shall be dealt in the next class. And continuing, next we're going to look upon the definition of a trade dispute, which is yet another important topic, and it is defined under the section 2 clause G of the Act. So a trade dispute is defined as any dispute between an employer and a workman, or between a workman and a workman, or between the employer and employer, which is with regard to the employment or non-employment, or the terms of employment, or the conditions of labor of any such sort. So the word dispute is comprised in 3 parts. That is, a dispute should be real. That means it should have the effect of compensating. That is, one party should be capable enough of compensating the other party. There should be some sort of settlement. So that is called as a real dispute. Okay. And one of the famous case that is covered under this section is workmen of the Makuchi Tea Estate versus the management of the Makuchi Tea Estate. So the facts of the case is as follows. So one Mr. Dr. Banerjee, he was appointed uh, as an assistant medical officer in the Nimakochi tea estate, and there was he was given 3 months probationary period, which was if he satisfied with the conditions, he shall be made permanent at a future date. So, if he is considered as unfit for the work, he shall be given a 7 days notice before terminating his service. And if he was found of any sort of conduct, then he'll be liable for instant dismissal. And if he was found suitable, he would be confirmed in the gardens services. So these were some of the conditions that was put forth by the Dimakuchi tea estate. And later on, one Mr. Booth, the manager of the tea estate, has terminated his service, saying that he was incapable of the said position. And later on, the Dr. K.P. Banerjee was represented by the Assam Cha Karamchari Sangh, and the said Assam Karamchari Sangh asked for the reasons which he was dismissed or terminated from his services. So it said that the Chief Medical Officer Dr. Kose had said that the Dr. Banerjee was incompetent to continue in his services. Initially, the said reason was that it was some sort of medical issue, but later on was said that he was incapable of even identifying the basics in a laboratory, and hence he was incapable of continuing the work. So that was the reason why he was terminated from the services. Later on, it was referred to the tribunal, and later on, the government felt that there was a need to refer the same to the tripartite appellate board. The tribunal that is constituted under Section 7 of the Industrial Dispute Act of 1947. And the main contention or issue was whether the management of Dimakuchi tea estate was justified in dismissing Dr. K.P. Banerjee, and if not, is he entitled to get reinstatement or any other relief in lieu thereof. So after a lot of contemplation, the said matter was referred to the Supreme Court. So the Supreme Court held that the word any person cannot be given a broad perspectives. It should be given a very limited meaning. And moreover, the Dr. K.P. Banerjee was not a workman. He was a medical or technical staff member, and hence he was not a laborer, and hence he was not classified under the category of workmen. And the court also could not establish that the said dispute falls under the Industrial Disputes Act, and hence the suit was dismissed. And hence the court held that it cannot be considered as an industrial dispute. So next we're going to look on the who all are the parties of the dispute. So the parties of the dispute, as I've already mentioned, is between the employers and workmen and workmen, and employer and employer, and then the subject matter of the dispute. So the subject matter of a dispute should always be connected to the employment, non-employment, or the terms of employment, or the conditions of labor of any person, etc. If it does not cover any of these, then it cannot be regarded as a trade dispute, and it does not fall under the definition. And the next one is any person. So as already given or stated by the Honorable Supreme Court, any person cannot be given a wide perspective or a wide connotation. The definition or the meaning should be limited or restricted, and hence it does not include any person anywhere in the world, but to the persons whose services are dismissed, discharged, or otherwise terminated. That's all, guys. So far we have looked upon the trade Unions Act of 1926, the scope of Trade Unions Act of 1926, the object of Trade Unions Act of 1926. We have also seen a few of the definitions, important definition. So the definition of trade union that has been enumerated in section 2 clause H of the Trade Unions Act. Then we have seen the definition of executives that has been defined under the section 2 clause A. Then office bearers defined under the section 2 clause B, and the definition of registrar that is enumerated under the section 2 clause F. And in the next class we are going to look in detail about registration of trade union. Thank you.